Good morning, our distinguished guests and participants. It's a pleasure to have you all with us here for today's seminar titled The Legal Landscape of Sukuk and Arbitration for Settling Its Disputes, hosted by the International Islamic Center for Reconciliation and Arbitration, or widely known as IICRA. My name is Vanessa, and I'm honored to be your host for today's event. We have actually received an overwhelming number of participants, and they have confirmed their physical registration at around 60 people. However, for some reason, unfortunately, some of them cannot come today, and others will be coming late. However, they can also catch us live on YouTube. We have a live video streaming on YouTube today. And they can also leave their comments if they have questions later on. We will also acknowledge them. All right, so to officially begin our seminar, let's listen to a welcome speech from the General Secretary of IICRA, Dr. Rami Sulaiman Abu Daka.
Thank you. Assalamu alaikum wa rahmatullahi wa barakatuh. Bismillah ar-Rahman ar-Rahim. Good morning, everyone. Ladies and gentlemen, distinguished guests and speakers. As the Secretary General of International Arbitration Center of Reconciliation and Arbitration, IICRA, it's my pleasure to extend a warm welcome to you all on this seminar entitled The Legal Landscape of Sukuk and the Settlement Dispute. At the outset, I would like to extend my sincere appreciation to the organizer of Dubai Arbitration Week. And I also wish to extend my heartfelt gratitude to all the distinguished speakers who have joined us today for exceptional gathering. Your presence reflects a collective commitment to advancing the legal framework of Islamic finance industry. Before we begin our sessions, and celebrating 20 years of IICRA establishment, I invite you to watch this video marking the 20th anniversary of IICRA. Please go ahead for the video.
The International Islamic Center for Reconciliation and Arbitration, IICRA, is an international organization dedicated to resolving disputes within the Islamic finance industry, serving as its trusted legal arm. Established in 2004 alongside the Organization of Islamic Cooperation (OIC) meetings, IICRA was founded to address the legal needs of the Islamic economy. As we celebrate 2 decades since our inception, we reflect on IICRA's foundational years, during which we built an administrative structure consisting of the General Assembly, Board of Trustees, and Executive Committee, similar to other distinguished international organizations. We have developed and continuously refined our arbitration and reconciliation rules, aligning them with the latest global standards, and look forward to launching an updated version in 2025. IICRA's governance frameworks, approved by its administrative bodies, uphold principles of independence, integrity, and professionalism, ensuring our services meet the highest expectations of the Islamic finance industry. Over the past 20 years, by the grace of Allah Almighty, we have transformed challenges into successes with the steadfast support of our founding members, member institutions, and the generous hosting of our headquarters by United Arab Emirates. Although we are relatively young compared to other international arbitration centers, IICRA has made significant strides in its mission. Through our services, we have resolved a variety of disputes in accordance with Sharia principles, and our arbitral awards have been successfully enforced across numerous countries. IICRA has grown beyond the center of dispute resolution. It has become a key legal resource for the Islamic finance industry. We have launched essential services and initiatives to support the Islamic economy from both legal and Sharia perspectives. including specialized training and certification for arbitrators and experts, conferences and seminars, and projects to codify Islamic financial transactions. Notably, we have pioneered model contracts for Islamic finance industry, starting with an Islamic model construction contract, created through the combined expertise of senior engineers, technical specialists, and Sharia scholars from around the world. All these initiatives, projects and many others that would achieve the mission and objectives of the IICRA as one of the most important infrastructure institutions for the Islamic financial industry would not have been possible without the unwavering support of the IICRA's member institutions. We extend our sincere thanks and deep appreciation to all Islamic financial institutions that stand with us in our mission. Our gratitude also goes to the United Arab Emirates and its visionary leadership for hosting IICRA's headquarters since its establishment. We reaffirm our commitment to advancing the Islamic economy and to positioning it at the forefront of the global stage.
Thank you. Dear participant, at the latest survey confirmed the Islamic finance has growth remarkably, with the global assets projected to reach 4 trillion by the end of this year and expected to surpass $6.6 trillion in 2027. The Sukuk market has played a significant role in this field, attracting investment from around over the world. In this GCC countries, especially we are talking alone, Sukuk issuance reached to approximately $75 billion in the first half of 2024. To give more figures and statistics about this field of Sukuk, we need to, if you don't mind, to invite our colleague, Mr. Mushir Ahmed, to give more statistics of the growth of Sukuk in GCC countries.
Good morning, everyone. I would like to start with a quick look at the global Islamic economy, which has been witnessing a significant growth over the past decades. Currently, Muslim consumers spend around $2.29 trillion globally across 6 main sectors. This spending is expected to reach $3 trillion by the year 2027 with an annual growth rate of 4.8%. This economy includes 7 main sectors, led by Islamic finance, which has assets valued around nearly $4 trillion. Other big sectors are halal food and Muslim-friendly travel, both at about $1.4 trillion. Modest fashion, media and recreation, halal pharma, and halal cosmetics are also growing quickly, with billions more expected in the next 5 years. Overall, the Islamic economy, often called the halal lifestyle market, has grown from $1.62 trillion in 2012 to $2.29 trillion in 2022, showing its steady and diverse growth. As the global Islamic economy continues to grow, one of the key drivers of this expansion is the Sukuk market. Let's dive deeper into the performance of Sukuk in the GCC region. I would like to discuss the performance of the GCC bond and Sukuk market in the first half of 2024. This period witnessed a significant growth, with total issuances reaching $75.5 billion across 173 sovereign and corporate bonds and Sukuk, making a 38% increase from last year. Conventional bonds led the market, making up 65% of the total at $48 billion, showing a 56% increase. Sukuk issuance also grew by 14%, reaching $26 billion. As of June 30, Saudi Arabia was the largest contributor, accounting for 49% of the market share. Now we have an overview of overall Sukuk market performance. let's explore how the Sukuk issuances were distributed across the GCC region. In the first half of 2024, Saudi Arabia was the dominant player in the GCC Sukuk market, raising $37 billion through 44 issuances, accounting for 49% of the total market. This is an increase from $32.9 billion raised through 37 issuances in the first half of 2023. The U.A.E. ranked second, raising $20 billion through 65 issuances, representing 27% of the total market share. This also marked an increase from $15 billion raised through 58 issuances last year. Other GCC countries like Kuwait, Oman, and Bahrain also participated, but Saudi Arabia and the U.A.E. led the market in terms of value raised in the first half of 2024. Having seen the geographical distributions of Sukuk issuances, let's now focus on a more detailed breakdown of the primary issuances across GCC. I would like to take a closer look at the geographical breakdown of the GCC primary bonds and Sukuk issuances in the first half of 2024. Saudi Arabia led with 49% of the total market share, raising the highest amount. The U.A.E. followed with 27%, with Qatar accounted for 14%, and Kuwait and Oman each contributed 4%, and Bahrain represented 2%. This shows that Saudi Arabia and the U.A.E. are the dominant player in the GCC market, with Qatar also holding a significant share. With this in mind, let's compare the performance of Sukuk issuances versus conventional bonds in the same period to understand how the markets are evolving. Now let's compare Sukuk and conventional issuances in the GCC for the first half of 2024. Sukuk issuances grew by 14%, raising a total of $26 billion across 31 issuances. The largest Sukuk issuance came from the Saudi government, amounting to $5 billion. On the other hand, conventional bond issuances saw a larger growth of 56%, totaling $48 billion. The largest conventional bond issuance was also led by Saudi Arabia, valued at $4.8 billion. This comparison highlights the continued growth in both markets, with conventional issuances remaining dominant but Sukuk continuing to show strong performance. In conclusion, we have explored the key aspects of Sukuk, and I trust this information will be valuable as we move forward with today's session discussions. Thank you for your attention. Now I would like to hand over the stage to Dr. Rami again. Thank you.
Thank you, Mr. Mashir, for this statistic and figures. Actually, it's very important to start our discussion today about Sukuk and the legal framework of Sukuk and how to settle the dispute for this field. It's a very important field in Islamic finance industry. Alongside with this growth, as highlighted Mr. Mashir in his presentation, they need development to strong legal framework aligned with Sharia principle has become extremely important. Thus, today's seminar will focus on addressing such these matters, including recent development or recent advancement in Sukuk, challenges in Sharia compliance, and the key strategy of effective dispute resolution, and what is the expected rule of the upcoming Sharia standard number 62 of IICRA standard to adjust all these issues. We are pleased to discuss such topic with the leading experts in this field, and I invited everyone here to participate actively, exchange ideas, and benefit from the expertise shares, together with the addressed challenges of contribute to support the Islamic finance industry. Thank you all once again, and we will look forward to a protective seminar for today. Thank you.
Thank you very much, Dr. Rami, for that warm words of welcome, and Mr. Mushir for sharing us the latest Islamic report. Okay, now for today's topic, the topics for today's seminar are the following: Number 1, recent developments and key challenges in the Sukuk market. Number 2, Sharia compliance in Sukuk, insights on the latest IUFE standards. Number 3, challenges in application of Sukuk in Islamic finance. And number 4, leveraging IICRA for effective resolution of Sukuk disputes. Our moderator for today is Dr. Suzanne Munir Abdullah. Dr. Suzanne is a distinguished legal professional with extensive expertise in litigation and arbitration. She graduated from the Faculty of Law at the Lebanese University in Beirut in 1998, and she furthered her studies with a master's degree with distinction and a PhD from the United Kingdom in 2008. With over 17 years of experience in the Middle East, Dr. Suzanne has handled a wide array of litigation and arbitration cases across various sectors, including real estate, construction, oil and gas, IP and IT, civil, commercial, banking, arbitration, and maritime law. She currently serves as a partner at OGH Legal, where she offers counsel in complex international disputes. Dr. Suzanne is also a dedicated educator, serving as a part-time lecturer at St. Joseph University and the Judicial Training Institute. She imparts her knowledge in civil law, e-commerce law, labor law, innovation and entrepreneurship, and intellectual property law. In addition to her professional accomplishments, Dr. Suzanne's recent appointment as a sole arbitrator and co-arbitrator with IICRA in several disputes related to Islamic finance highlights her esteemed reputation and expertise in the field. Dr. Suzanne will now take over to introduce our distinguished speakers for today's seminar.
Good morning, everybody. Thanks, Vanessa. Thanks, Dr. Rami, for this welcome session. Hello, good morning, everybody. Thanks for this welcoming introduction, Vanessa and Dr. Rami. As Dr. Rami said, today's seminar is on the hot topic in arbitration. It's a legal landscape of Sukuk and arbitration for settling its dispute. So why we have invited our speakers to discuss how to effectively navigate and manage Sukuk dispute, recent development and key challenge in the Sukuk market, and Sharia compliance, especially taking into consideration the IUFE new draft standards that has been released recently, and the best way to handle effectively Sukuk cases. I will start with Bashar. We know that Sukuk, as it's like often referred as Islamic bonds, are financial instruments that comply with Sharia principles and provide alternative way for investment. Can you, just because we need to make sure that the audience are fully aware about today's discussion, give us an introduction about Sukuk and whether there is like difference with, key difference with debt bond?
Thank you very much. Assalamu alaikum wa rahmatullahi wa barakatuh. Good morning, everyone. I'll start with that, but I am privileged of having a legal firm and a Sharia firm, so I'm sure they will complement the picture. But maybe because we actually sit independently, it's a good place to start with. So maybe just to take one step back, why Sukuk exists. So it came because there was an actual need of issuers of debt to have debt being raised in a Sharia compliant way. So the starting point is, at the heart of it is Sharia. So there is no doubt that this is the actual push. And people on the other side had money that they wanted to invest in, and they wanted to invest that money in a Sharia compliant way. And if we're talking about the modern Sukuk that we're talking about now, at that time, I mean maybe more than 16 years back or 20 years back, I was in IDB, in the Islamic Development Bank. And there we were trying to have the first international issuance of Sukuk coming from the region. I mean, Malaysia has done few before that, but it was not in a format that's there. That took more than a year. So launching the first, I would say, international sukuk in the region, which came from the IDB, it took from a year. The discussion was not only with bankers, because if you're talking usually with banks, you'll have legal firms, but they have something that they call plain vanilla bonds, which they can pull from the shelf, more or less. I'm not undermining what you do, but it's less definitely time-consuming. And then you will not have the Sharia side. You'll have the bankers, you'll have the rating agencies, and all of that. In the Sukuk case, at that time, we had to come up with a structure that satisfies Sharia, that satisfies the issuer, satisfies the investors, satisfies the bankers, regulations, and credit rating agency. Because at the end of the day, a rating will enable an international issuer or a regional issuer to be able to compare. So why is rating important? Because at the end of the day, if you say, this is from U.A.E. BBB, and this is from Honolulu BBB, they have the same comparability. So it allows comparability. So at the end of the day, all of that has been pooled, and there is a lot, and I'm sure both of you can really elaborate on that, to come up with how to have that instrument. At that time, the thinking was to say, okay, let's try to see how we can accommodate that from a Sharia perspective and have the lawyers structure something that satisfies Sharia and still have a credit profile that is acceptable to the investor. And that's the way that it was actually structured. I'm trying to simplify it. So it will have the obligations, and here I'm using the right terminology, that will ultimately mimic the obligations of a bond. But in a bond, the principal and what they call interest is guaranteed from day one. So you will get that from the actual, generally, from the actual bond, you'll say, this is how much you're going to pay, this is how much you're going to get, and that's it. And it's in one, I would say, in almost in one contractual obligation, more or less. And I'm again trying to simplify it. Where in Sukuk, to arrive to the same thing, you actually have to put the relevant underlying asset to make an actual underlying activity or asset or a transaction that is generating income. So you have to have something that's giving you income. You cannot just get income on money. So the thinking behind that is, of course, in IDB is different, but now we have various, the industry has moved along very quickly where you have various methods where it could be asset light, it could be asset heavy, it could be murabaha, ijara, hybrid, wakala. So the alternatives moved on. But the key principle did not change. You have to have an underlying asset that will generate income and that will also allow you to sell something and buy something that will generate also a principal mechanism. And again, I'm trying to simplify it. Of course, each Sukuk structure is unique. For us, we recognize even in our criteria that each structure has to be assessed on a case-by-case basis. So we don't have a blanket for Sukuk, because you could have an Ijara Sukuk issued by a bank in Saudi Arabia and another Ijara Sukuk, although I'm simplifying Ijara, but you could actually have differences in the way that the obligations are set. Of course, if it's usually hybrids where, i.e. you have a wakala or another side of it where it is that. So, as you can see, at the heart of Sukuk, you have Sharia, legal, credit risk, and of course, the actual issuer. Because if you're talking to a government, what they can put under the underlying is different if you're talking to a small corporation, or if you're talking about Etihad Airways, or Uridu. So the actual underlying will change, and the way that the contracts are drafted will change, ultimately. Now, taking that and putting it in a dispute manner, and I hope I'm not taking a long time because I have to run around 10:15, 10:20, so I'm taking some more time, and please excuse me for that. So when you have that, you have now a product that has obligations. In our rated universe, it's pari passu to a bond. So if I am rating a Saudi Arabia Sukuk, and I'm rating Saudi Arabia, and I'm talking about the government, and I'm rating Saudi Arabia bonds, they carry the same rating. The same applies if I'm talking about the government of Turkey, or the sovereign wealth fund of Saudi Arabia, or the sovereign wealth of Turkey that we've done just recently. So whatever we do rate, and if we assign the same rating, and here you see F, then it carries the same credit implications. And that is easily said than done. We have an actual specific criteria where we explain how we rate Sukuk. So we go through the whole thing. Now let's assume that I've explained why we have Sukuk, how Sukuk is really structured and what is there. If we're looking at the rated universe, more than 81% of the Sukuk that we rate is investment grade, which is BBB minus and above. And that's a significant part of the international Sukuk market, by the way. So we do rate a significant part of the international Sukuk market. And the other 19% is what we call speculative grade, which is below BBB minus. Why is that relevant? Because that is an indication of the quality of the Sukuk that you have. And usually, the lower rated, you would expect more dispute there. And you will expect more there. But in terms of default, we really have not seen significant default in the Sukuk industry. Specifically the ones that went in and out of court. And again, that will come in the discussion, and maybe we'll have the example of Dana Gas, and we can elaborate on that. So you can see that you have an instrument that you're starting with. The instrument is young in nature compared to the bond market. It's objective, and key features are based on the factors that is there. But I don't know if Qadir or Ammar wants to add anything on that.
نحمد ونصلي على رسوله الكريم سبحانك لا علم لنا إلا ما علمتنا إنك أنت العليم الحكيم. It's a privilege to be here to discuss the important topic of Sukuk. I think extending the discussion which Brother Mashar had. So one key element in Sukuk is it's a marketable security. So what does it mean? Because the entire Sukuk structuring exercise that you see, why do we have hybrid Sukuk, for example, or what structure choices are determined, is actually determined by the requirement to make it a marketable security. Marketable security is something which must have a secondary market. Why do I say this? Because the question was, if you see the industry expectation around a fixed income instrument, which is a bond, for example, is that the risk appetite of the investor is low. They are looking at, let's say, capital protection with fixed revenue streams. Otherwise, if the investor would want to have high risk, high return, they already have access to, the equities and the other markets, other marketable securities. Now, in this space, not just the investors, the other key dimension here is, if you see the Basel III and the other norms that are coming up, any Islamic financial institution, for that matter, is required to have on its books near cash securities, because they are not expected to deploy every deposit that they raise in long-term finance. Now, how do we address this issue is the key point in Sukuk. Technically, Alhamdulillah, Dr. Salam is here, a renowned Sharia scholar. We can structure a Sukuk, fixed income Sukuk, with a fixed rate as a pure debt, which will mimic 100% a fixed income, bond, by, let's say, doing a commodity murabaha. Why don't we do that? Because it will not make it a marketable security. So this entire exercise of how we determine the Sukuk structuring is driven by this requirement to make this instrument marketable security, and at the same time trying to capture or trying to integrate, let's say, the requirement of the market or the expectation of the market to make it similar to a fixed income conventional instrument. Second point here is, we all know that from a Sharia perspective, how we move money is very important. What is moving money? So from the investor's hands, which we call as Sukuk holders' hands, to the obligor's pockets, and how do they come back? This is the key question that we have to address as Sharia practitioners. So what is that contractual element, or what is that contractual nature where the money will flow, money will go out into the pockets of the obligor and come back to the sukuk holders? There you see various structures. The initial ones being the ijara, the mudarabas for tier ones, the hybrids, the service agency, the ATKM, the throughput capacity, different structures are there. We will discuss if we have more time. So that was a bit of a clarification, sort of extending the discussion that Brother Bashar had.
Thank you, Bashar. Thanks, Ammar. One more question, Bashar, before we run away. So, in your view, what's the best model to listing sukuk in the financial market?
I think listing by itself is in part of the tools that I think we've discussed. It's to allow tradability. So if I am to simplify the process, I think listing comes maybe at a later stage, but I mean, of course, at a later and early stage, because it will allow you to tap the right investor pool. You will need to have the right infrastructure regulations that allows you to be able to list a sukuk. Because sukuk by itself, it's a specific instrument. And the largest current, and you'll be maybe surprised, the largest current listing destination for US dollar or foreign currency sukuk is actually Ireland. And then you have London Stock Exchange and the DIFC not far behind. But these are the top three listing destinations when it comes to sukuk. Now that is something that you need to consider, but at the end of the day, it is what you're putting under it. So what you're really giving the offer. And I think you tried to talk about marketability. And since I might not have a chance to talk about that, we've had in the past 2 years the introduction of IICRA Sharia Standard 59. That by itself had a lot of challenges, but one of the challenges that it was actually embedding in it, the ability to sell debt. Because the selling debt in Sharia is something that has its own complex way, and why am I not saying it's not allowed? Because you have people in Malaysia that have murabaha, that they still see that you can one way or another do a sale there. The interpretation on what we're looking at, and IICRA 59 introduced that. That means that under a certain conditions where you have less tangible assets in a sukuk, and here I'm going into a complex discussion, it will be delisted. Delisted, i.e. it will be taken from the stock exchange. But not only that, if it goes beyond another threshold, depending on the sukuk that you're looking at, and for a longer period, and it's not substituted, it's actually either a put option or a dissolution event. So it's an actual credit event. So the sukuk now has embedded in it triggers that will do delisting, that will have, because of Sharia, and it will have a dissolution or a put option because of Sharia. These two elements were very limited before 2 years and before Standard 59. So that's another angle that you need to look at. We're not entering yet into the discussion of the draft Standard 62, because that, in my mind, of course, we don't know how the final one will look like, and who's going to adopt it, and the way that they're going to adopting it. So for me, we saw the draft standard, we have views on it, but still draft. Then we will see who is going to adopt it and the way that they're going to adopt it. And that is what's going to determine the level of disruption of the market. How is it going to be treated, the lengths of the market, who's going to adopt it. All of these factors will really determine the impact. But if you look at the draft, you're talking about, I mean, you can have 4 scenarios. One of them is more likely than the others, but if you're talking about securitization, for example, and asset-backed securities, they're still a debt instrument in the conventional side of things. But they are almost non-existent in the OIC countries. So that debt level does not exist. And I'm not talking about sukuk. I'm talking they are almost non-existent in the bond market. So securitization is not there because you don't have investor appetite for that. And some of that is linked to the legal systems, and this is maybe relevant to the discussion here, legal systems and their development in countries of OIC countries. And here I'll just cite one example. So we have a criteria that we call country-specific recovery criteria in Fetch. And under that criteria, we have more than 14 countries of the OIC countries. We rank countries based on the recovery in the distress scenario, A, B, C, and D. The highest is A. And if I am looking at the OIC countries, you have none of them in A. You have 2 of them in B. You have 2 of them in C. And the vast majority is actually in D. So the actual legislative systems and the way to resolve dispute and achieve recovery is not mature. And I'm not talking here about Sukuk. I'm talking about bonds and in debt in general, let alone Sukuk and its additional complexity. And here, the various options that are open to resolve that dispute becomes essential, because you don't have a legal system that is tested, although we've seen many of these jurisdictions developing their bankruptcy laws and becoming more friendly or trying to become more friendly, credit friendly, but they're untested in some of them, in few of them actually. But that's untested, and that continues to be a key challenge there. And here I think we've seen a lot of cases being resolved outside. So I've done the quick link there.
Okay. Okay. Ammar, do you have any addition, or Qadir? Yeah.
Bismillah ar-Rahman ar-Rahim. Good morning, everyone, and thank you for braving the traffic and making it here. I know it's been challenging for many people. So maybe just to add some introductory comments based on what we've heard from my fellow panelists. From a legal perspective, as has been alluded to, a sukuk is effectively put together through a combination of different contracts. So let's take a very vanilla ijara sukuk. You will have your sale agreement, you will have your lease agreement, you will have your service agency agreement, you will have your purchase undertaking, you will have your sale undertaking, and then from a capital markets perspective, you will have your declaration of trust, and you'll have your paying agency agreement. And then obviously you have your terms and conditions. So I've already mentioned 7 or 8 documents. Now, where it becomes more complicated is that the governing law of some of these documents will be different. So if you're doing an ijara sukuk, for example, the sale agreement and the lease agreement has to be governed by the law where the physical asset is located. So if you have a U.A.E. obligor and you're doing an ijara sukuk using real estate in Dubai, the sale agreement will be governed by Dubai law, the ijara agreement will be governed by Dubai law, but the rest of the documents will be governed by English law. So when you get into the world of a conflict, it gets quite complicated because you potentially have conflict of law issues. How do you resolve an issue where you have different governing laws in different contracts? And also different dispute resolution provisions in different contracts, because if it's governed by Dubai law, then usually it will be subject to the jurisdiction of the U.A.E. courts. If it's governed by English law, it could be subject to the jurisdiction of the English courts, or it could be subject to arbitration. So it becomes very complicated on international transactions when you're in a restructuring type scenario, or when you're in a distress scenario trying to work out actually what is the correct analysis and what is the right way to navigate through some of these complexities. Now, we haven't seen many sukuk, alhamdulillah, go into distress. Obviously, Dana Gas is one that was all over the newspapers 2017, 2018, and we can talk about that in a little bit more detail. As a English lawyer, obviously what investors are looking for, and I'm talking purely from an English law perspective, and I appreciate there's Sharia requirements that need to be balanced against this. But what investors are looking for is certainty. They're looking for as much comfort as possible. That's why our capital markets documents, our declaration of trust, our purchase undertaking, etc., are all governed by English law. English law is supported by hundreds of years of case law. It's supported by hundreds of years of jurisprudence. So we can then say to investors in the offering circular, in the legal opinions that will be issued, that we are confident that if this was to be disputed over, if it was to be litigated over before the English courts, then the English judges would give effect to this as a matter of English law and would uphold the provisions of the English law contract. That is very important, and I need to emphasize how important that is in international sukuk transactions, because if you cannot give investors that legal comfort, then they will not be interested in buying the sukuk, even if it is fully Sharia compliant. Even if, obviously, the legal consequences has a direct impact on your rating in any event, but if we cannot give that comfort, then it's a problem.
Ammar, do you have anything to add?
I think all practitioners do realize, and we've had our leading Sharia scholars always, emphasize that any transaction for it to actually go to market, in addition to it being Sharia compliant, it has to be legally enforceable and commercially viable. So that's where I think the whole structuring exercise, engagement with the law firms, and all those aspects come into play. So it's not that the Sharia scholars do understand that point and position.
Qadir, what are the main provision of the special purpose vehicle in Sukuk? Bashar and Ammar, you can add after.
Yeah. So other than a few very limited exceptions, Sukuk transactions will always have SPV, which is established, SPV being a special purpose vehicle. And the SPV is, again, subject to certain limited exceptions, is usually established in an offshore center, like the Cayman Islands is usually the preferred one, but there's other centers or jurisdictions which are also used. And the reason why we use the Cayman Islands is because the Cayman Islands recognizes the concept of a trust, which is fundamental to all the international sukuk issuances. So when you have the sale of the assets, when you have the lease back of the assets, when you have the ijara agreements, etc., the obligor is entering into those contractual arrangements with the SPV. The SPV is effectively a conduit vehicle which then holds the assets on behalf of the investors. So the SPV will buy, in the case of the ijara sukuk, will buy the asset from the obligor once it receives the money from the investors. The SPV will lease the asset, again, on behalf of the investors, back to the obligor. And all those activities which the SPV is undertaking is effectively through a declaration of trust. So it buys the asset in its capacity as a trustee, it leases the asset in its capacity as a trustee. All the cash flows that it receives through the ijara agreement, through the service agency agreement, through the purchase undertaking, etc., all those cash flows that it's receiving in its capacity as trustee. So here we have a perfect alignment between Sharia principles and English law principles, because from an English law perspective, if you receive something as a trustee, you obviously have to pass it back to the beneficiaries of the trust. And that's perfectly aligned with how a sukuk instrument works from a Sharia perspective. There's a few very limited exceptions, and we probably don't need to talk about them in today's session. There's also some country-specific exceptions. So for example, if you're based in Turkey or based in Indonesia, those are the two examples that spring to mind at the moment. The domestic law in those jurisdictions allows specifically an SPV to be set up in those countries. And it also recognizes that the SPV, even though they're both civil law countries, it recognizes the SPV can act as a trustee on behalf of the investors. And this probably brings me to another point, which is, I'll just mention, but we don't need to go into a lot of detail. You have certain countries, again, like Indonesia, like Turkey, like the Philippines, which have a specific law for the issuance of sukuk. So to allow a Turkish obligor to issue sukuk, you have to comply with the Turkish sukuk law. To allow an Indonesian company to issue sukuk, it has to comply with the Indonesian sukuk law. Most countries in the world do not have a sukuk law. The U.A.E, we do not have a sukuk law. Yes, we have laws around what is a murabaha, what is an ijara, what is a musharaka, what is etc., etc., but we do not have a specific sukuk law. And that's the case in the vast majority, in fact, all the GCC countries, and the vast majority of countries across the world. So that's a slight difference, again, from a legal point of view.
I'll just say a few things before I leave. And for me, I am passionate about Sukuk and Islamic finance. So leaving this discussion is hard to me. But I'm speaking in another event, so I have to leave, so excuse me. But I think one important point to complement. For us, we're looking at all of these contractual obligations, including the SPV. What is the implication from a credit point of view? Because at the end of the day, does it play a role? Does it have an implication? And usually, the actual credit strength of the instruments does not lie with the owner of the SPV, which is usually an orphan. We call them orphan SPVs. It lies with the actual obligor, i.e., the actual issuer backing up these obligations. Not the performance of the underlying assets, although they have their own way of complementing the picture, mostly from a Sharia point of view. But the ultimate risk lies with the obligor, and that is the vast majority of Sukuk we rate. We do rate Sukuk that are asset-backed, which is, I would say, one out of the vast majority. So if I'm looking, we have one issuer that we rate that has asset-backed, and all the remaining ones, and we rate around 220 instruments. It's around $200 billion outstanding dollars as of this quarter. That's a significant part of the US dollar market. And the vast majorities is what we call asset-based, i.e. you have the underlying asset there. The role of the SPV could actually change, and I'll leave that with you, if Standard 62 is panning out, and how is the transfer of assets on the legal side. Please excuse me, I really need to leave. It's a pleasure here, and it's hard to leave you, but if there is anything, please do reach out, and we can maybe arrange something. Thank you very much. I have to leave. Thank you.
Do you want to add? I think you want to add something.
No, I think Brother Qadir has highlighted the requirement. So there is alignment from a Sharia compliance perspective on the matters that relate to the SPV specifically, because that is the intermediary through which the contractual intermediation happens between the obligor and the movements of fund. So until the SPV, we have the certification process where the proceeds are received and certificates are issued. The actual contractual obligation happens between the SPV and the obligor. So like the example that Brother Qadir gave on Ijara. So the Ijara asset purchase agreement, the lease agreement, all those list of documents, contractual documents are between the SPV and the obligor.
Ammar, what happens when Sukuk has defaulted? I know that there is no such lots of cases, but what happens as a general like? It's a hard question, I know.
Yeah. The parties go to court.
I
think...
okay, let me rephrase it. If a party, let's say, go to court. For you and even for Qadir, both of you have done provided lots of Islamic financial advice on Islamic financial products and services. And definitely during your advisory work, you had faced some challenges, and it was led to enforcement, to take enforcement process before the Dubai court or local courts here. What key challenge you have faced before the court for Qadir and for Ammar?
Yeah, I mean, I would say that I'm a transactional lawyer. I'm not a litigator. I'm not an arbitrator. So I obviously don't appear before the arbitral body, or I don't appear before the judges. But the challenges all stem around from making sure that the contractual obligations are enforceable as a matter of the governing law, which is usually English law. And to allow any international counsel or English firm that's advising on the transaction to get to a position where you're comfortable to say that requires an analysis of not just how the English courts or how an arbitral body that's applying English law would look at the document, but ultimately, if this ended up back in the jurisdiction of where the obligor is based, how would they look at the document and how would they apply the provisions of the document? And maybe I'll just spend a couple of minutes talking about Dana gas because it is quite relevant. So Dana gas was a mudaraba sukuk, and it had a purchase undertaking. I won't get into the Sharia rights and wrongs of that, but that's how it is structured. The mudaraba itself was governed by U.A.E law because Dana gas is a U.A.E based company. And what a mudaraba is effectively from a Sharia perspective, it's a partnership. One person, i.e. the SPV, provides the money to the obligor, the mudarib, and the mudarib invests that money to generate a return. So that mudaraba agreement was governed by U.A.E law. The purchase undertaking, however, was governed by English law. Now, what the purchase undertaking stated in the mudaraba, in the Dana gas situation, was that in the event that there was insufficient money being generated by the mudaraba, the SPV could effectively sell the mudaraba assets to the obligor for an amount that was required to redeem the sukuk certificates in full. So the principal amount plus any accrued and unpaid profit. Now, if you look at the U.A.E Civil Code, the U.A.E Civil Code makes it very clear that a mudaraba arrangement cannot be guaranteed. In a mudaraba arrangement, the Rabb al-Mal takes the risk on the capital being lost if the mudaraba doesn't perform. In around that time, 2017, 2018, Dana gas was in some financial difficulties, and effectively the argument it tried to run was that the mudaraba is not a guarantee under U.A.E law. The SPV and therefore the sukuk investors are taking the risk of the business. If the business doesn't perform, if the business doesn't generate a profit, then the investors should accept that risk because that's what a mudaraba is under U.A.E law. It was disputed before the Sharjah courts. It was disputed under the the English courts. The Sharjah courts held the whole contractual arrangements to be unenforceable. The Sharjah court said, yes, a mudaraba agreement cannot be guaranteed under U.A.E law, and therefore there is no obligation on Dana gas as mudarib to pay profit where the business has not generated a profit. And therefore, the whole contractual arrangement is unenforceable as a matter of U.A.E law. There was parallel proceedings in England because the purchase undertaking was governed by English law. What the English judges said is that we are looking at the purchase undertaking from a narrow concept, just from a purchase undertaking perspective. This is a document that's governed by English law, and this is subject to the jurisdiction of the English courts. As a matter of English law, parties are free to agree commercially whatever they want to agree, and we will give effect to what the parties have agreed. And the purchase undertaking is very clear that if there is insufficient profit being paid under the sukuk certificates, then the SPV has the right to sell the mudaraba assets to the mudarib or to the obligor, and Dana gas has to pay the pre-agreed price. So we were in this very strange situation where the U.A.E courts were saying one thing and the English courts were saying something else. Now, from a lawyer's perspective, you never really know how something is going to work until it's been litigated. And I'm glad that this was litigated because we now have case law from the English courts as to how they look at these things, which is very, very important for investor confidence. Because if we didn't have this, let's assume that we ended up just with the Sharjah judgment and no English law judgment. Quite frankly, the sukuk market today would not be in the position that it is in today because investors wouldn't be investing. So that litigation was very important because it gave investors comfort that from an English law perspective, this all works and is enforceable. Now, ultimately, when the English law judgment was given, Dana gas came back to the table and the whole deal was restructured and it was renegotiated, and there was a consensual way out through the problem rather than trying to enforce the English law judgment here in the U.A.E. But what that highlights is the complexity of these contractual arrangements, particularly when you have different governing laws, when you have different jurisdictions. Now, I'm sure we'll come on to talk about the benefits of arbitration, and could some of this be made simpler through arbitration? But that, to me, making sure that we are comfortable that the contracts are enforceable as a matter of English law, and we have the precedent and the case law from the English courts to give us that comfort is critical again.
Correct. Ammar, do you have?
Yeah, I think to add dimension to the case, if you see Mudaraba itself, so we have two parties or two partners sharing an asset. So if you look at this case of Dana Gas, so it was, I think, if I remember correctly, $500 million Sukuk, which was originally issued in 2008 and then reissued to mature in 17. So when the investment was made into the company, so what is the definition of Mudaraba assets? Is it like a ring-fenced asset which is separate, or is it commingled asset of the company? So these questions are also very important from a Sharia perspective, because if it were to be, let's say, taken a step further, and there was, let's say, a judgment to carve out the assets, to enforce, probably, let's say, purchase undertaking is not available, for example, just for the argument's sake, then what happens in the Mudaraba? Mudaraba means that at the time of the creation of Mudaraba, what was the contribution of the parties into the Mudaraba assets? First, what is the Mudaraba asset and what was their contribution? And then, when you actually go to the liquidation in 2017 or whenever that date would be, you have to carve out the assets in the similar proportion as per the, the Sharia principles, prorated to their original ratio of contribution. What purchase undertaking does, and the key point of difference here from a Sharia perspective is, because a partner cannot guarantee the other. So in Mudaraba, two partners, one being the Mudarib or the manager, and the other being the capital provider or the Rabbul Mal. Now, purchase undertaking is an instrument which by itself is not problematic. It gives an exit mechanism to the investors. Otherwise, investors are not interested in carving out and taking the assets home. Now, the key Sharia point here is, which actually is debated and discussed between the, for example, from a legal perspective and from, probably the rating agencies may have some interest in that, and from a Sharia perspective as well, is can we have a purchase undertaking at a predetermined face value? So, for example, if the actual carve out of the asset means that the asset value is lost, original contribution was 500 million, and then now if we have to actually liquidate, it's coming to 450, for example. So is it permissible from a Sharia perspective to have a purchase undertaking at face value? That is a key point that was discussed amongst the scholars. And the guidelines are out there very clear. So by itself, purchase undertaking is not an issue. It's whether the exercise price can be pre-agreed. So that was the key aspect here. And like Brother Khadir mentioned, it was not enforced, it was negotiated and amicably settled, I think, out of court.
طب عمار, what are the mistakes that we need to be avoided in the application of Sukuk?
I think Sukuk, number one, thank you for sharing the numbers initially. I think it was very helpful for all of us to also understand that it's now a systemic industry. So when I say systemic, it means that it's not like 2004-05 where probably one or two issuances were happening somewhere in some regions. It's now part of the mainstream industry. Systemic regulators are looking at it and they are aware of it. So the key point here is, we need now the approach of how these instruments can be made passportable. How, let's say, an issuance is coming from Bahrain, how it can be globally accepted. Issuance is coming from Saudi Arabia, how it can be globally accepted. So the industry, because it seeks to grow further, this is the key point of how this passportability can be achieved. Now, the challenge in this would be aligning ourselves with the common minimum acceptable standard across the board. Is that possible? Yes, of course. I mean, if we, that should be possible. or at least we have to make that possible eventually. This is the whole challenge that we have. How can we structure an instrument and make it passportable across? And for that, of course, we need standards which are commonly accepted across the board. Not just by a jurisdiction, by a country, by a set of scholars, but across the board. So that when issuer comes in, how can that be achieved? By choosing the right structure for an underlying set of commercial, legal, and any other requirements, rating agencies. So given a set of requirements, do we have the Sharia structure or the ability to structure a sukuk which will meet all the expectations? Number one, being passportable from a Sharia perspective, and also, like Brother Qadir mentioned, from a legal perspective, being acceptable across board to all the stakeholders. In this, I think the exercise is going on to see what are the common structures, or at least for example, now I can give an example of tier 1 issuances. Now, I would say that the market has pretty much standardized the tier 1 issuances, which is on the basis of mudaraba. So similar approach or similar, exercise because you see market has a classification of sukuk other than Sharia. So you have senior secured, senior unsecured, subordinated, depending on the profile of that instrument. So how can we let's say, align this market expectation with the Sharia structuring approach? Number one, is that possible? If that is possible, in what way that is possible? So these are the questions that I think are out there open for us, and we always seek advice and guidance of Sharia scholars to see how we can align the market expectation with the Sharia structuring approach that we may need to have.
Thanks. Qadir, do you want to add anything?
No, I think Brother Miles touched upon the two key points: standardization and fragmentation. I mean, we've been talking about this for many years. We're obviously working, and the world is moving towards standards, and that's the primary function of IOFI, and we'll come on to talk about that in a minute. The adoption and the implementation is maybe a little bit slower than what the market would like, and we regularly run into issues. Well, okay, if we follow this approach for the U.A.E. market, maybe another market is not yet in the same position, and therefore we have to change the approach if we have an obligor from Egypt or from Turkey or from Indonesia, for example, and vice versa. I think the more we can accelerate the standardization, so there is common Sharia standards which are applied across all the markets, certainly all the key markets, that will definitely help in growing the market, because there will then be uniformity. And it will also help in the understanding of the market, because I think also there's still a misunderstanding or a lack of education sometimes about what these instruments are, what do they mean. I mean, some people think that just because it's been done in the U.A.E., you can just pick it up and replicate it in KSA, or if it's been done in KSA, you can pick it up and replicate it in Egypt. Unfortunately, it's not that easy, it's not that simple. So having a little bit more awareness about some of these instruments and the standardization approach is definitely going to help.
Thanks. Could the new Sharia standard disrupt the Sukuk market in 2025? With the new IOFI draft standard has been released recently that seeks to redefine the concept of Sukuk and its underlying structure. I know that Sukuk has gone through lots of challenge and experience here, but do you think the U.A.E. can adapt these changes?
You've put me on a spot.
I know.
I think the importance of standardization is out there. No need to emphasize more on that. Now, if you look at the standard number 62, which I think in circulation for industry feedback, and rightfully so. And if you also notice that the exercise of taking industry feedback on 62 has been so extensive that I've not seen any other IFE standard going through these many cycles of, feedbacks and active participation and gathering various views and opinions across. So we've had a session in U.A.E., in Pakistan, in Malaysia, in Saudi Arabia. So the standard setting body is actively taking in the inputs. So that's a very positive, outcome. So disruption is not the right word. Why? Because see, any change, for example, if you look at U.A.E.'s market, we've had a sort of a regime change from 2018, where we had pre-HSA era and post-HSA era. 2018 banking law in U.A.E., and then the higher Sharia authority, and then the requirements of, So whenever a new change is introduced, people have probably take time to understand. However, like I highlighted, it's a systemic industry, and I'm sure the regulators will take note of this aspect. They do have the power to probably, if the standard comes out in a form, I am sure it will come out in a form which is acceptable to the industry, number one. And secondly, the process of implementation, like with every other standard. I'll give you an example of standard number 61, and specifically from U.A.E.'s case on cards. So the regulator, when the standard came, they've allowed the industry about, I think, more than 2 years' time to actually implement that standard, understanding fully well that there will be a process of learning. There's a learning curve associated. So I think it will not be disruptive. One, the regulators are aware of this. Whenever it comes out, it will align with the market expectations based on the feedback that they have received from the industry. And if at all, if you look at the standard itself, the nature of the standard is, they've always been a standard on mudaraba. They've always been a standard on ijara. So mudaraba standard will always say purchase undertaking at the face value is not acceptable, for example. Now what the exercise of 62 is to align, or to, let's say, to borrow from the existing IOFE standards and put it in a place to address any specific issues that may, or if that structure is adopted for Sukuk, how it may play out. So it's not reinventing the wheel. It's not that they have changed the standard on the mudaraba. It's only that they have aligned, mudaraba. So if you're issuing a Sukuk mudaraba, what are the nuances, what are the requirements of, and then specific questions around that. So that is our take as probably, part of the stakeholder engagement and exercise. I would leave it to, Brother Khadir or any other panelist to.
I would say whenever there's a regulatory change in any market, there's always disruption. And I don't mean that in a negative sense. It always takes time for people to readjust and realign with the new regulatory environment. I think it's very important that there's a transitional phase where we move from the current environment to IOFE 62 being fully implemented. Because I think if it happens without a transitional phase, then I think the impacts would be quite significant. I mean, that's my personal view. There are a few provisions in 62 which I think are very, very helpful. And I fully agree with the kind of the spirit behind this, which is to make Sukuk as it exists today more Sharia compliant. And that's very admirable. And I think we should all support that. I mean, at the end of the day, we should all support that. But we also have to realize that Sukuk can only exist in the framework of the global financial system. And you have to work together with the global financial system to make sure that the Sukuk industry continues to survive. So a transitional arrangement, I think, is going to be necessary with a phased implementation. That would be very helpful. But I think the ultimate goal and the ultimate objectives, we have to support.
As we heard from the expert about the challenge and complication of Sukuk here in U.A.E., Dr. Rami, it would be ideal if we have a quick idea about IICRA, the general and special advantage of arbitration under IICRA, how does IICRA maintain its specialization in handling with Sharia principles, and the arbitrator appointed by IICRA, how they handle legal issues in related to the subject matter? Probably you can elaborate and highlight on the Sharia law pursuant to Article 35 of the rules and the higher Sharia committee that sometimes give an idea for the, or like guide the arbitrator before they issue the awards.
Thank you, Dr. Suzanne. Actually, I have, before going to the answer of your question, I have some comments here regarding the facts that rising by my colleague here from rating perspective, from Sharia perspective, but we are totally agreed that if we need to settle the dispute of Sukuk, we have to cover three perspectives: legal perspective, Sharia perspective, and technical perspective, since the Sukuk related to the actual business as you are raised. That's why when we talk about those perspectives, from the beginning, we are talking about the technical perspective. If, as per the kind of the Sukuk, if it's Murabaha or Ijara or Salam or whatever, or the kind of Sukuk, here in U.A.E. law, as you are well known right now, they cover this kind of product in our commercial law or commercial transaction law. They arrived or stipulated the definition of this kind of products. And in our also in companies law of U.A.E. law, they talk about the SPV, Sharika Dhat al-Gharad al-Khas, the SPV companies. And he put a lot of provisions of that. That's why, let me to add here some suspense, because I'm not agree with distinguished speaker about the environment, legal environment of Sukuk. We are not ready. Always we are talking, we are not ready about the Sukuk. Mr. Bashar, he combined between the Sukuk and the bonds, and he talked about the legal the environment in other countries. That's why we are going to the law, to the English law. In fact, we have here in U.A.E., actually we don't have a specific law for the Sukuk, but meanwhile, the central U.A.E. Central Bank raised a decree to adopt all the standards of IUFI as a law. So once we get all the standards of IUFI as a part of the law of U.A.E., that's why that legal, from legal perspective, we are covering this issue by adopting the standards of IUFI. Okay, there is a lot of remarks about the IUFI standards, whatever this we can discuss and we can cover it by the practice and by the deals that are going on. But from Sharia perspective also, we have the Sharia as IUFI standards, and we have a higher committee in U.A.E. Central Bank. They cover all the issues of the Islamic products. And from the technical perspective as well, we have a lot of expertise, and we have many arbitrators and experts are involved in the topics and the technical issues of the Sukuk. That's why if you want to cover or to handle the settling the dispute according to Sharia, you have to cover these three steps or these three perspectives: the Sharia and the legal and the technical perspective. That's why when we settle the dispute according to IICRA rules, we are not going to hire arbitral panel combined or composed of one arbitrator or sole arbitrator. Always we are going to the three arbitrator in order to cover the whole perspective, the Sharia. So we can hire one of the Sharia scholars, expert, and from the law, to cover the legal perspective, we have to hire the lawyer who is involved in the Sukuk. And for the technical issues as well, you have to hire one of the experts in the involved in the subject of the dispute. That's why, by this way only, you can cover the whole perspective to settle the dispute of Sukuk. That's why the standard number 62 in article, I think, number 14, they mentioned clearly that if you want to settle the dispute of Sukuk, you have to go through the Islamic arbitration. This, we are.
My last question for you is that between Article 14 of the draft standard Sukuk, IUCRA standard Sukuk, and ICRA rules, because there is reference to Sharia and like institutions that deal with Sharia. Probably I was going to ask you to elaborate, you or Ammar, on this point. What do you think about this Article 14?
Of the 62.
62, yeah.
I think before giving any opinion, it's a draft standard. So arbitration itself, like Brother Qadir mentioned earlier, if you see, you have complex multi-jurisdictional disputes where there is a propensity or the probability that the parties may go to different courts for settlement. So arbitration is something which is internationally accepted now. So from a Sukuk perspective as well, it's a very positive, let's say, and a welcome step if something of this sort can be built in and can be expanded to be applied to Islamic financial instruments and Islamic financial transactions, and provide, because you see, we have now, like Brother Rami mentioned about U.A.E. and the U.A.E. based laws. Yes, they are there. But if you see a recent issuance now, it was by one of the largest aircraft leasing companies in North America, AirCap. Now they technically, why did they do a Sukuk? For them it was more of a commercial interest, because they were not, they saw the market, they saw, the availability of liquidity in this market, so they tapped this market. Their corporate itself may not be fully aware of what IOFI Sharia standard is and what are the implications. And what they rely on is probably the opinion, the ability to adjudicate, the ability to litigate. And they take help from experts like scholars and lawyers and other stakeholders. So in that capacity, if a comfort is provided through this provision or through this mechanism that these Islamic financial institutions can have recourse to arbitration, where they can settle their disputes through the mechanism that is set out, that should be, a very welcome and acceptable proposition for the stakeholders in the industry. Would you?
I would just maybe add that some of the transactions that we have already done and continue to do, we already have arbitration in some of the transaction documents. But the analysis is more around, is it easier to enforce an arbitral award in the jurisdiction of the obligor, or is it easier to enforce an English law judgment? So if I take the example of Turkey, for example, whenever we do international Sukuk issuances in Turkey, we always have English law, but arbitration, because we know Turkey is a party to the New York Convention on Arbitral Awards, and therefore it's very easy to enforce an international arbitral award in Turkey. Now, the arbitration rules that are usually chosen are the international rules that everyone is aware of, that international investors are aware of, so LCIA, UNCITRAL, etc., etc. So the concept of arbitration already exists in some Sukuk transactions, but the analysis of whether you use arbitration or not is really driven by enforceability of judgment versus enforceability of arbitral award. Now, what Dr. Rami, I think, is asking the market to consider is a wholesale shift of everything to be governed by arbitration. And again, I understand the merits of it, but I think you also have to think about the practical consequences of the ability to enforce that arbitral award. Let's say you have a Sukuk issue from Saudi Arabia. It's very difficult to enforce an arbitral award in Saudi Arabia. Let's say you have a Sukuk issuance from Egypt. Also very difficult to enforce an arbitral award in Egypt. It may be easier to actually have English courts. So I don't think it's one size fits all. I think you have to do an analysis based on the circumstances and the facts of the individual issuance, and where there is an avenue for arbitration, then yes, we should be exploring arbitration, and if IICRA can support that and IICRA can become the body to help that, then that's great.
Totally agree, brother, with the investors in Sukuk. They are always not familiar with the arbitration proceedings to settle the dispute, regardless the issues of enforcement, because as you know, all the arbitral awards should be binding and executed as per the international agreement or under international, especially New York Convention for binding or for enforcement the arbitral awards. Regardless the expertise of in KSA or in Egypt, there is two ways or two things here. The method of settling the dispute, that should be arbitration, and the governing law. If the English law is sufficient in order to settle the legal or Sharia issues in Sukuk, this is the question. If the English law, if the provisions of English law enough to cover the whole Sharia perspective in Sukuk, we are going to implement that law. But since, as you know very well, that the Islamic products in English law are not defined at all. Okay, we will back again to the principles of the law in order to talk about the murabaha and salam and ijara, but as a definition, we don't have this definition in the English law. That's why the standard of IUFI standard number 62 suggested the Islamic arbitration in order to implement the settlement of the dispute in Sukuk by the arbitration, because the arbitrator will apply the governing law, but should be not conflict with Sharia principles. But if you put this subject or this matter or this case under the court of London court or English court, they will consider this issue regardless the provisions of Sharia. This is the issue, and that's why we are preferring the Islamic as the IUFI standards stipulated that the best way in order to settling the dispute of Sukuk is the Islamic arbitration.
Just like last comment, between arbitration and even here local court, we all faced when we file cases before the court will be appointing expert. I had dealt with a case, it was a murabaha case, and the court appointed was an accounting expert. The accounting expert was, the way he was calculating, like he was calculating interest, and he was like, it was totally different than murabaha perspective and background and all this. So the problem is not only about English system will apply, even like, is there calibers or people specialized in these topics. I'm talking about the simple one, which is murabaha, which is the simple. It's very simple comparing to sukuk. So the application sometimes it's not like the court, you know, here, U.A.E. court, when the expert will submit a report. Sometimes, most of the time, they take the report as is, and based on the report, they will issue judgment. If the calculation is wrong, if the concept of murabaha wasn't taken into consideration in the report, how we are going to expect like a judgment in relation to this subject matter. So we had a fight, we had a battle, we had to remove the expert from the task because we said he's not specialized in murabaha. The way he's calculating, it's like more conventional and not like as per the murabaha or AUFI or Sharia standards. So it's not only English law, it's not only English court, it's even like you need the calibers who are ready to handle or to specialized in this field.
Yeah, correct. I'm totally agree with you, Dr. Suzanne, especially we are talking about the arbitration. One of the main features of arbitration is the specialization. Through the arbitration only you can choose your arbitrator. In the court you cannot choose who is the arbitrator, who is the judge, what is his background. But in the arbitration, one of the main feature of arbitration, the parties has the right to choose the arbitrator, and he can check what his background, what his expertise, and which field he is. That's why we are talking about the arbitration as a solution. I'm not talking about jurisdiction of England jurisdiction or any other jurisdiction, but I'm talking about the features of arbitration, giving the solution to settle this kind of dispute smoothly. So we're talking about the specialization, we're talking about short time of settling the dispute as a feature. Within 6 months you can settle the dispute, approximately, definitely. We are talking about the globally, in the arbitration you can apply multiple or any jurisdiction, but in Islamic arbitration, you have to care how the arbitrator should be issued the arbitral award compliant with Sharia principles.
And like you said, Rami, so I have the chance to be appointed with IICRA in several cases. What's unique for IICRA, for example, is the time for issuing the award. We manage like, it's 6 months in the beginning, but can be extended. However, the average for issuing the award under IICRA rules and IICRA, under the IICRA establishment, so it's like between 4 to 6 months. So why this reason? Like Rami said, Dr. Rami said, the arbitrator, the tribunal, they are specialized, so they don't need to appoint expert to give opinion on the subject matter. IICRA, the main concern for IICRA is when they appoint the tribunal, they make sure they have one Sharia scholars, one legal probably, and one specialized in, for example, let's say Sukuk and like some Islamic services. So to be able to decide on the matter without the need to appoint expert to give opinion in something that the arbitrators themselves, they are specialized to do so. You want to add? Yeah.
So anyone who has questions, you may please raise your hand. Okay.
Thank you for this session, very helpful and very informative. Mohammed Negma, I'm a partner, Tamimi Law Firm, Dispute Resolution, based in Saudi Arabia. Related to the arbitration award, you can enforce arbitration award in Saudi Arabia because Saudi Arabia is a part of New York Convention. The challenge is when this arbitration award has a part not in a compliance with Sharia. Also, there is one reservation from Saudi government, reciprocity, or when we have a country or arbitration award issued in jurisdiction not recognize Saudi arbitration award. There's only one observation or comment related to this statement. Saudi Arabia is very friendly for Sharia compliance arbitration award, and even it's easier than a judgment. If you have an English judgment and the English arbitration award, it's easier to enforce English arbitration award than the judgment itself. So that's a comment or observation. Thank you.
Thank you, bro, for this comment. As I mentioned clearly, that Saudi Arabia and Egypt as well as partner was adopt the New York Convention, 1958, I think, yeah. And they can enforce and IICRA also awards applied already, enforced already in Saudi Arabia and in Egypt as well. Maybe in Sukuk there is some, I don't know, maybe Mr. Qadir will give us more details about this cases here we are talking about. But as New York Convention, there is more than 198 countries are adopted and recognize this convention. So this convention allowed everybody to settle or to enforce the arbitral award in their in these countries. And Saudi Arabia, they can refuse to adopt or to apply or enforce arbitral award if that award against to the public order or nizam al-am, public order. If it's against the public order, since Sharia public order in Saudi Arabia, that's why they are not enforced.
Thank you for the comment. And just to clarify, I didn't say you cannot enforce an arbitral award in Saudi. I said it was difficult because of the public policy exception. I mean, I'm not going to argue with an arbitrator in Saudi Arabia, but I'm aware of arbitral awards that have not been enforced in Saudi Arabia because of public policy. I'm sure there are many that are enforced, but again, I didn't say that you cannot. I said it's difficult.
If the arbitral award conflict with Sharia, definitely you cannot afford enforce it in Saudi Arabia as a part of the public word. This issue, not in Saudi Arabia, in many Arabic and Islamic countries as well. Since the convention, so the New York Convention giving this option for the countries, if the arbitral award conflict or against the public order in this country, they have the right to refuse the enforcement in their land. Doctor, تفضل.
بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا محمد وعلى اله وصحبه اجمعين. السلام عليكم ورحمه الله. Thank you very much for this very, I would say, interesting topic. My name is Salim Al-Ali. I have two questions for Qadir. So I think you have made a statement, or maybe I would say about U.A.E. Sukuk law. So my question, do you think this statement, you said in U.A.E. we don't have a U.A.E. Sukuk law as compared to Indonesia or Turkey. Do you think you would revisit this after, would say, 62 being implemented fully? And if no, what do you think the elements that are missing to call it U.A.E. Sukuk law? So this is the first question. The second question is about Dana Gas and the English, I would say, judgment. I mean, I just wanted to understand from purely English law perspective. English law will not take into consideration or how English law will look at the combination of contracts. So is it issue of, I would say, form over substance, or it is the issue that English law will not take into consideration the other contracts in this set, you know? This is very important if you can elaborate more on this point. Thank you very much.
Thank you so much for your question. On the first question, I mean, I would query whether we need a Sukuk law in the UAE, because in most GCC countries, there's a very healthy and mature Sukuk market, and there is no Sukuk law. We obviously have all the underpinnings, so we have the CTL, the Commercial Transaction Law, we have the HSA resolutions with the IOFI standards, etc. So these all underpin everything we do. CTL, the Commercial Transaction Law, is very clear on Murabaha, very clear on Ijara, etc., etc. Now, when 62 is adopted, maybe you can say there's a Sukuk law, but I don't look at it as a Sukuk law. I look at it more as a framework that is aligning the underlying Islamic instruments with how you bring them to the capital markets rather than a Sukuk law. When I say Sukuk law, it's more when I look at places like Senegal, or I look at places where they have specific laws which allow Sukuk to be issued, and from a regulatory perspective and from a tax perspective, they treat it the same as conventional bonds. And it's more important in these jurisdictions, because if there wasn't a Sukuk law, then actually you couldn't issue Sukuk, because when you sell the asset, all of a sudden you find you have to pay capital gains tax. Or when you lease the asset, you find it's a regulated activity. So a Sukuk law is required just to create a level playing field in those environments which maybe don't have an underpinning of Sharia. On your second question, the English courts were looking at the very narrow question of only the purchase undertaking. And that's because when the case was filed, it was only filed where the judges were asked to apply and interpret only the purchase undertaking. So the English judges said, well, you've asked us to issue a judgment as to whether the purchase undertaking is enforceable as a matter of English law. They were not asked to look at the mudaraba. They were not asked to look at anything else. So the judges can only be asked to do what they're being asked to do through the filings. So on that very narrow question, they looked at the purchase undertaking only.
Allow me, thank you very much. But from English law perspective, if the case has been filed, let's say, about the Sukuk entirely, would they, I mean, as a precedent in the English law system, they will look at the combination of the contracts, or they will only look at the purchase undertaking?
No, so it very much depends. When you make the filing to the English court, you have to set out what your argument is. So if your argument is, we have a dispute under the purchase undertaking, we have a dispute under the Ijara agreement, we have a dispute under the terms and conditions, they will look at every contract you refer to. So if you refer to all the contracts in the filing, they will look at all of them.
On the Sukuk law, Dr. So IICRA is the body which regulates the marketable securities. So if 62 comes in, it will become a reference. So IICRA already has some provisions on the Sukuk. You know, what is a marketable securities? They have combined it with the other instruments, other securities, to create that enabling environment. Now the question would be, is this Sukuk being issued in the market for the retail investors, or, you know, for someone to access it? Now if you see most of the issuances, these are for, you know, slightly above retail. So technically that point of law, because if you have to issue any security in a local market, you have to abide by the law, because law not just deals with the governance, with the structuring, but the governance, how a Sukuk is governed. If you see, one of the arguments in Dana Gas case was, and now this has been mitigated to an extent, which was the Sukuk issuances, when they were issued initially, the banks that were the underwriters or the lead banks, they facilitated the Sharia approval process. But we all know that this being a marketable security, on day 2, all of these banks can exit by on-selling it to the investors, the Sukuk holders. Now, the capacity to have an ongoing governance layer, that has to be, you know, driven through the legal system, that if an issuer is there, if the issue is here listed, how it will be governed from a Sharia, adding that layer of Sharia governance. Now we see with Sukuk issuances, DFSA has updated, and other regulators, that there is a mandate to have a Sharia advisor throughout. So IICRA, as we know, last They were in process of doing a Sukuk law, specifically addressing that. I'm not sure if that has seen the light of the day, but this is something, just to add.
Thank you very much for the excellent and very informative presentation. I'm Grace Chang, an English barrister and arbitrator with 39 Essex Chambers in London. I have a question regarding the use of experts, which we heard towards the end of the presentation. So I understand that in selecting arbitrators, arbitrators will be selected on the basis of their expertise, such that experts would not be required. I was just curious to understand whether there may be certain instances where experts may be necessary and may be used in IICRA proceedings. So with regards in particular to certain IICRA rules, I was wondering whether there may be any differences with any other rules of other arbitral institutions.
Thank you for your question. Actually, IICRA rules is not, there is no big difference between IICRA rules for arbitration and other arbitration centers. We are following the UNSTRAL arbitration rules. We are adopting the same. But there is a model, there is a big or best practice for arbitration. We are following that best practice in arbitration. The main issue here, how to ensure the arbitral award should be compliant with Sharia. This is a question. For this reason, IICRA has a list of arbitrators who are experts in Islamic finance field for each transaction. This is first of all, we can suggest these names to the arbitrator or to the parties in order to choose their arbitrators. Okay. At the end of the day, we have arbitral award. The draft of arbitral award before going to recognize from the, or before the adoption from the arbitrator should be go to the higher committee, Sharia higher committee inside IICRA. If there is any conflict with Sharia, they should highlight this point to the arbitrators that there is a conflict in Sharia on this point, and they should reconsider these points in order to make the arbitral award compliant with Sharia principles. That's why we are talking about the Islamic arbitration, not conventional arbitration. This is the main issue. There is many other things as a features of arbitration under IICRA rules. We are non-profit organization, so our the cost of arbitration in IICRA 2%, not maximum, from the total value of the claim. This percentage reached to 20% in ICC and another arbitration center, as you familiar with this arbitral centers, as you. As Mr. Qadir, there is some familiar proceedings internationally. But here we are talking about the Islamic finance. We have the arm of Islamic finance to settle the dispute according to Sharia principles. So we cannot compare between IICRA and other arbitration center because our field is specialized in Islamic finance only. So in IICRA you cannot issue any arbitral award conflict with Sharia. This is the issue.
Under Sharia, there is no interest. Arbitrator cannot give him interest, like in any conventional center or even before local court. Claimant can ask for the let's say the outstanding amount, and in addition to 5%, 9% interest. This is not applicable in under IICRA because we apply Sharia law. So, and like I said before, always when it's like a tribunal composed of three, there is always the head of the tribunal is Sharia. So whatever requirement related to Sharia, he's the one who is guiding us. In addition to the higher commissions that Dr. Rami just mentioned, it reviews the award, but it gives some guidelines without even affecting the decision of the arbitrator. So it's guidelines, they want to take it, fine, they don't want to take it, they are still free, but the most important, we have already in the tribunal one of the Sharia scholars, and he specialized in Sharia. I think that's it.
Thank you for taking my question. Maybe we have passed the time. My name is Badr Al-Jafari, an arbitrator and commercial lawyer from Saudi Arabia. I have a question. Perhaps the main goal for issuing Sukuk is to provide finance or financing for a company. However, recently I came across, I could say, unusual goal for issuing Sukuk for two companies in Saudi Arabia, which is under a procedure of financial restructuring procedure, FRP. In these situations, the purpose of issuing Sukuk was to convert the creditors from their position as a creditors to Sukuk holder. So the company has issued Sukuk equivalent to the credits, which is in one company about 6 billion Saudi riyal, and the other company is around 2 billion and 500 Saudi riyal. And the creditors became Sukuk holders based on a Murabaha agreement. So my question, because actually this is, to me, is unusual. Is it internationally? This is, I mean, a common practice, or how do you see? Because, you know, in FRP, there is a process of years to finalize the process of the FRP. And currently, those companies are in the beginning of this plan. So this is my question. Thank you.
I mean, I also welcome views from my fellow panelists, but I mean, it's not uncommon for a company to restructure its liabilities by issuing Sukuk, a new instrument. And we've seen this on many occasions in the U.A.E, and we've seen it in other jurisdictions as well. I can't comment on the specifics of a FRP process, but I've certainly seen examples and worked on examples where a company has managed its creditors, managed its liabilities by issuing different kinds of Sukuk. In some situations, actually, they've changed the debt liability to equity by issuing a Mudaraba Sukuk to replace something else. And I've seen this and I've done this. So ultimately, it's what is in the interest of a company from a recapitalization process. Do you need to reduce the debt liability? Do you need to increase the equity side of the balance sheet? Again, without fully knowing the specifics of a FRP process, to me, we've seen it before. I don't know if you'd like to comment.
I think probably it was driven by the requirement to provide an exit to the creditors. So Sharia structure, of course, is important, and how it is done and what was the distress and what are the assets, that part being aside. Because ultimately, a marketable security will provide, let's say, the holders of that security an exit mechanism. Otherwise, if the company, without any capacity to pay quickly, gives a, let's say, a long-term binding contract which is not marketable, it will then be difficult for those creditors to exit. So in the form of a marketable security paper, even for, let's say, the value, whatever they can make out of that paper, they can sell and exit. So it's probably driven more by the commercial factors, and like Brother Qadir mentioned, some of these have been done in the past. You know, now, maybe 2010, 11 also we have seen and done some issuances along these lines.
It's been a very meaningful discussion. Thank you very much, our dear panelists, and of course, to our distinguished participants for your active involvement. And we have also our participants online. Thank you very much for joining us today and for enriching the discussions with your active participation. This time, I'd like to invite again Mr. Mushir Ahmad, IICRA's Head of Communications, for his closing remarks.
Good afternoon, everyone. As we draw our seminar to a close, I would like to begin by expressing my sincere gratitude to our esteemed speakers and moderator for their insightful discussion, as well as to our distinguished audience for sparing your valuable time to attend this seminar today. Your active engagement and commitment have truly enriched today's session, and it is with great pride that I say the objectives of this seminar have successfully achieved. Our purpose here has been very clear: to support the growth, integrity, and the betterment of Islamic finance community. As such, I would like to take this opportunity to highlight some of the key recommendations that IICRA is honored to present today. Number one, we strongly recommend all dealers in Islamic finance industry to incorporate IICRA arbitration clause in their contracts and agreements. We also encourage those with existing disputes to utilize IICRA by signing IICRA arbitration agreement as a pathway for a fair, just, and Sharia-compliant resolutions. Number two, IICRA advises dealers in Islamic finance sector to invite legal experts and jurists to avail IICRA services, which include dispute resolutions, consultations, and a specialized training program. This will enhance their understanding of industry's Sharia legal and technical perspectives. Number three, we urge all infrastructure institutions within the Islamic finance industry alongside legislative bodies to support the legal structure of Islamic finance. Enacting relevant laws and supporting IICRA's initiative in its institutional reconciliation and arbitration will drive our industry forward. Number four, IICRA recommends industry leaders to organize more conferences and seminars for Islamic finance professionals, arbitrators, experts, mediators, and aspiring legal practitioners. These gatherings are essential for professional development and exchange of insights that shape our industry. Number five, for those wishing to deepen their expertise, we highly recommend attending IICRA's CIA training program, as this program offers an invaluable opportunity for participants to enhance their skills and knowledge in Islamic finance and arbitration. Number six, for parties involved in dispute resolutions, IICRA's e-platform offers an efficient solution that reduces the need for travel, saves times, and minimizes accommodation expenses. Last but not the least, we call upon Islamic finance professionals here and those tuning in remotely to consider availing IICRA services in handling of their financial disputes. By actively promoting IICRA's role within your networks as well as beyond, you truly contribute to the ongoing development and stability of the Islamic financial landscape. In conclusion, IICRA remains steadfast in its mission to support a harmonious and robust Islamic finance community, as we look forward to your continued engagement and partnership in this journey. Thank you once again for your active participation, and we hope this seminar has provided you with valuable insights to guide your work in the years ahead. Please join us for refreshment as we continue to build our connections and further our discussion. Thank you very much.
Thank you very much, Mr. Mushir. It has truly been a rewarding seminar. Before we conclude, once again, IICRA is inviting you all for our upcoming conference on the 28th of November, followed by a workshop on the 29th of November at Kempinski Central Avenue Hotel in Dubai. Okay, it's next to Dubai Mall. Our conference is proudly sponsored by Abu Dhabi Islamic Bank, Sharjah Islamic Bank, and OGH Legal. For those interested in registering, kindly reach out to me or to Mr. Mushir after this seminar. And we will be playing a video teaser of the conference, so please take a look. Again, thank you very much, everyone, for your participation. And we are inviting everyone to have some refreshments outside. It's the perfect opportunity for us all to continue building those important connections. We'll also be taking a group photo, so please stick around for a quick picture to commemorate this remarkable gathering. Again, this is Vanessa. Thank you all for your participation, and we look forward to seeing you all at IICRA's upcoming events. Have a good one. We would like to request our photographer to take a photo of our distinguished speakers. We will be giving or handing over them our certificates. Okay, so the certificate reads, this certificate is presented by International Islamic Center for Reconciliation and Arbitration to Mr. Qadir Latif in recognition of his distinguished participation as speaker at the seminar, The Legal Landscape of Sukuk and Arbitration for Settling Its Disputes, held today, 14th of November, 2024, at Millennium Plaza Downtown Hotel, Dubai. Please give him a round of applause. The same certificate is awarded to Mr. Ammar Ahmad. And the same certificate is awarded to Dr. Suzanne Munir Abdullah for her distinguished participation as our moderator for today's event. Thank you very much, Mr. Ammar Ahmad, Dr. Suzanne Abdullah, Mr. Qadir Latif, and of course, Mr. Bashar Al-Natur, sorry, for coming over today and giving us insightful discussions. The same certificate would be given to Mr. Bashar Al-Natur later on. Again, let's have some refreshments outside and we can take photos together as well. Thank you all. You're